So, disabled children and their legal rights, securing care and support for vulnerable children. Very grand title, what does it mean? Very difficult to explain very easily what it is that we do in terms of trying to build the foundation for disabled children that might allow them to have the full life that they deserve and will then lead to them being able to access full care, full support, a full life, full education. But in the context of what we're talking about today, I hope it's useful in terms of being an ancillary issue which we see as being the foundation of the work we do as a unit. So perhaps the easiest place to start is by way of an example. And this is lovely Charlotte. In this picture, I think she's about 4 years old. I first met Charlotte when she was 5. She'd been discharged from hospital where she'd been since birth, some 2.5 years after her birth, because she was very, very poorly. She has a condition known as Rett syndrome, which is very complicated. I don't know the full extent of the implications, but would say that on any reasonable view, she certainly required 24-hour care. Now that's a phrase which is very often bandied around by any number of people, not least parents, quite rightly, because it denotes a serious level of care and support required for somebody who is profoundly disabled. And that's true whether you're a child or an adult. She was discharged from hospital and she was supposed to be receiving a full package of jointly funded care. Now any of you who've been in contact with social services and the primary care trust will know that the idea of joint funding and working together and cooperative planning is not necessarily as easily done as it might be. And what should have happened was there should have been a meeting at the point at which Charlotte was discharged home, a very happy moment for her and her family, where the primary care trust and social services together with the family, the whole family, Charlotte, her parents and her 2 older siblings, knew what it was going to happen after her discharge, understood exactly what care and support services were going to be in place to enable her to move back into the family home for the very first time and have the platform for that full and independent life that she deserved. Of course, it didn't really work that way. By whatever means, what actually happened was that Charlotte was discharged home with a less than adequate care package, whereby she wasn't receiving care and support, in addition to the great love and care and support that the family were providing for her. So that, for example, there could be suitable rest periods, waking care overnight, and so on and so forth, because of genuinely life-threatening conditions. And there was a huge shortage of actual practical assistance in the home to assist the family lead their full life with Charlotte home. And so what happened was the parents, both hugely dedicated, both working full-time, both looking after 2 teenage siblings, were becoming exhausted, not least because of their caring responsibilities, but because of their battles with the primary care trust and social services. And I'm sure you don't need me to tell you that that's no easy battle to have. It's exhausting. Are you hitting your head against a brick wall? Are promises made which aren't delivered? Are we moving forward in any way in terms of getting additional care and support? And ultimately, they reached a point where they were genuinely exhausted, where they would have been on any view a family in crisis. No family necessarily wants to go to social services, for example, and say, we are in crisis. There's all the wrong connotations in terms of how people perceive you as a family. It could raise child safeguarding issues, child risk issues. It shouldn't, because we'll see in terms of the Children Act, and those provisions are there. And so they were a little bit reluctant, quite rightly I suspect, to raise the issue of social services in the context of that emotive language. But that was certainly the point that they had reached, and it's at that point that the parents came to see me. So what do we do about that in terms of what it is that we can see as a way forward, a way of resolving some of the difficulties that people face, which are not too dissimilar to Sophie's case, in terms of there being a problem there, where somebody is being a little bit obstructive, or a lot obstructive, and is simply not listening to you. Well, the starting point for us, and the starting point for any child in need, is Section 17 of the Children Act. The Children Act, as many of you will know, was enacted back in 1989. It's a huge piece of legislation with great chunks of guidance that goes with it in terms of the idea of providing whatever care and support services are necessary to promote the health and well-being of children in need. It is always, always the base of anything that we say or do in terms of getting additional care and support for children who, for whatever reason, and obviously in the case of the people that we help, because of their disabilities and their consequent care needs, need help and assistance of any kind. And this is always the touchstone. Section 17 of the Children Act is deliberately wide. There is a general duty of every local authority. Duty in a legal context means you have to do it, i.e. there's no getting away from the trigger duty to carry out core assessment of care needs if you present to a local authority on the basis that you may be a child in need. You may be a child in need. Very low threshold. Yeah? So if you were to go to a local authority and say, I'm struggling, I think my family needs a little bit more assistance, we maybe need a little bit of a short break provision so we can recharge our batteries and better care for our son, then that's a trigger for the social services to undertake some form of assessment of your child's potential care needs as a potential child in need under Section 17. Promote the upbringing of such children by their family by providing a range and level of service appropriate to those children's needs. Very broad. And just in general terms, and I'm sure perhaps you don't need me to tell you this, anything is possible. You can come up with a wish list of what it is that you think you as a family or what your child needs, and it's for social services to then go through that wish list. Putting it in these sort of straightforward terms, because I don't see any reason why we shouldn't, because it's ultimately about what you as parents who understand your child best believe your child needs. Is that a child in need within the context of Section 17? Yes. Are they likely to need some care or support? Well, what do you think? Put it to social service on the basis of your understanding of your family's circumstances and your child's needs, and it's for social services then to make a decision as to what it is they are willing to or not willing to provide services to meet any identified needs. Everything is possible. They have to make a decision as to whether they are going to provide care or support services, and your response to that is why, for reasons which we'll see in a little while. So that's our foundation. Section 17 of the Children Act then leads to Section 2 of the Chronically Sick and Disabled Persons Act 1970. The law, as you can probably gather, can be a bit dry and boring sometimes, but these are hugely important pieces of legislation. What this means is that all of these services which are set out there are services which can and, in your view, should be provided. So anything is possible, and it's for social services to carry out a comprehensive child-centred assessment in accordance with the framework for the assessment of children in need and their families. Very chunky, very detailed guidance issued by the Department of Health back in 2000, but which gives you some very interesting snapshots of what it is that the local authority should be looking at in terms of sort of identifying what that particular child's needs are. So again, everything is possible, and that's the way you should approach it. We also have the National Framework for Children and Young People's Continuing Care, again Department of Health guidance. This is here because these are the particular issues that we raised in Charlotte's case. And Charlotte's case is not unusual, certainly not in my experience, I'm sure not in yours. Charlotte was a profoundly disabled child, but even if she didn't have such a high level of care needs, these are the pointers that we would be coming to in any event. And again, we'd be putting this to social service on the basis of what assessment have you undertaken? What have you decided? And tell me why you've decided it if you're looking to restrict or block services of any kind. So in terms of tackling social services and family care first, our starting point was obviously to get hold of the assessments they had done, go through that quite meticulously, indicating where in those assessments they'd missed things or where they'd misinterpreted things. Why was it when they've got a general duty to carry out a comprehensive child-centred assessment which involves all those who can contribute towards the identification of what this child's circumstances are, what their care needs are, in which the parents are hugely, hugely important, because for the very reasons that Joe and Catherine were saying before, they are their own experts. Why is it that the PCT and social services have simply failed to recognise the true extent of poor Charlotte's care needs? And why is it that we don't have a 24-hour care package? And why is it that social services are only funding 17 hours of personal care per week, rather than the 55 that we think, in our view, should be provided? So we get the care assessments, we go through them meticulously, we draw up our own assessment in effect, we try and marry that up with the social service and primary care assessments, and then if we have to argue it still further, we say to both of them, well look, in terms of the Chronically Sick and Disabled Persons Act, anything is possible. We think in terms of the services that are available, you should be providing these services listed here. You tell me why it is you're not going to provide those, given the wealth of evidence available from the parents and the consultants to indicate that this is a child in need who requires a higher level of care services. And so from our perspective, what do we also use? Well, human rights, as we'll see in a second, much maligned in this day and age, sadly, but hugely, hugely important, not to be sniffed at all. Never feel afraid to be able to quote human rights quite readily. 3 articles of the European Convention on Human Rights, 1957, post-war. We wrote it. It's now enshrined in our legal system because of the Human Rights Act 1998. So we are entitled in any situation where we're dealing with a public authority or a public body like social services, a local authority, or the primary care trust, or central government, we're enabled to argue that the decisions they're taking are not only unfair and irrational, with reference to what we call public law principles, but also they are a potential breach of my child's human rights and my human rights as a parent and my other children's human rights. And the 3 that I most readily quote, there are plenty of others, Article 3, the prohibition of inhuman and degrading treatment. Now I have to say Article 3, because of various cases in Strasbourg, is a very high hurdle to overcome. And in terms of being able to actually establish that decisions of local authorities are inhumane and degrading, is not going to be easy. What's missing in terms of like the article here is it also relates to the prohibition of torture. And so the courts have usually interpreted Article 3 along those kinds of lines. Now obviously that's sort of like Charlotte's circumstances and the circumstances of many a child who's not getting the high level of care services that they need, such that the family is descending into chaos. Is that inhuman and degrading? On any common sense view, let alone a lawyer's view, yes is the answer. Are we going to get the courts to recognise that? Sadly, no. But it doesn't mean to say that I shouldn't be arguing it in the context of the circumstances that we're setting out in arguments for social services. In my view, quite the contrary. Do we think that that's inhuman and degrading on any reasonable view, regardless of what Article 3 says? Yes. Article 8, again, hugely important, the right to respect privacy and family life. It's the right to respect. It's not an absolute right. But those who are making decisions which we think infringe upon our privacy and family life, which clearly decisions to restrict services will do, it's having a hugely negative impact upon the family. Is that sufficient respect for that family and their privacy and their family life? Again, common sense tells you no, it isn't. Can that be justified? Is that proportionate in any way? Well, possibly, depending upon various issues which the local authority or the primary care trust must raise, and we'll perhaps see how that might be panned out a bit later. And Article 14, the prohibition of discrimination. Prohibition of discrimination on any basis whatsoever. In this instance, we would say that that's discrimination because you're not having sufficient respect for a disabled child. You're not providing the level of care or support on any reasonable view which you might provide for somebody who wasn't disabled. And again, from our perspective, because our remedy in this case, as it would be in any number of other cases, which Liz will touch on too, is judicial review, which sadly many of you may have gone down the road with judicial review. Very, very helpful remedy in terms of being able to argue things through, give you a certain leverage in terms of let's do your arguments with the primary care trust and social services, but is nonetheless a very old school, common law based, very clunky, time consuming, very costly legal process in the administrative court, which is part of the High Court. So it's not like nipping down to the county court to issue proceedings in relation to disability discrimination, which is relatively straightforward. Even from a lawyer's perspective, it's quite clunky. But it's the only remedy we've got, short of complaint, short of negotiation, short of hammering on the door. And when we threaten judicial review, we really mean it, because it's a remedy of last resort. You do not go to the High Court unless you think we've got a good case. And we think from the off, and certainly in this case, and many cases like it from the off, if we do not get social services and the primary care trust to significantly shift their thinking in terms of the care package which they've put in place, bearing in mind the abject failures at discharge where they should have put the package in place in the first instance, because there is a wealth of guidance and legislation to indicate their duties to carry out the comprehensive child-centred assessment at that stage, then basically we would be moving forward with judicial review pretty rapidly. I'm not going to waste any time here because this is a family in crisis. This is a family who desperately needs some assistance. What kind of assistance? Well, frankly, that's for social services, the primary care trust and the family to knock together in a common sense, cooperative way. Thankfully, after a good deal of pushing and pulling, after a good deal of further arguments, a good deal of positioning ourselves in terms of coming to the brink of judicial review proceedings, we were able to see a significant leap forward in terms of the primary care trust and social services. I have to say, somewhat begrudgingly, sitting around the table and actually massively increasing that care package. Still not perfect, we're still missing some of the adaptations to the family home, and it's an ongoing battle in terms of some of the looser ends, but in terms of the core care service, we're close to 24-hour care with waking carers, with short break provisions, so the parents at the very least have opportunity to recharge their batteries, still be happy that they're looking after the other two siblings, and Charlotte is being looked after by sound, sorted care packages. So that's just a snapshot of perhaps the kind of thing that we're talking about. Human rights, what are they, why are they important? Our great leader, Daily Mail, 17th February 2011. David Cameron declared war on unelected judges yesterday after they put the human rights of paedophiles and rapists before public safety. The Prime Minister said he was appalled that Britain's 50,000 sex offenders can appeal against being kept on a police register for life. I could very easily have quoted David Cameron talking in exactly the same terms and being quoted in the Daily Mail in exactly the same terms about the recent issue which has cropped up again about prisoners' votes. Same principles are in play. This is the European Court of Human Rights in Strasbourg apparently telling us what it is that we're doing wrong and how appalled we all are by that. Well, we have the Human Rights Act 1998, so why on earth our Prime Minister is appalled about our own legal system baffles me. And that's not me talking as a lawyer, that's me talking in terms of something which is frankly there for us all to see. If it wasn't spun in the way in which it's spun in the media, not just by the Daily Mail, but by ill-informed journalists, because it's a sexy story about the Tories wanting out of Europe and so on and so forth, we might better understand what human rights is about. And if we did, we'd be more empowered in terms of the arguments and issues that we want to raise with those who've got significant roles to play in terms of decision making, which have a huge impact upon vulnerable people. I'm not just talking here about disabled children, I'm talking about all the people that I help. Adults, children, older people, people with learning difficulties, people with mental health problems. They all are, by definition, vulnerable people. They are entitled to protection from the law, and that includes the Human Rights Act. So from my perspective, it's not me on my hobby horse about it. It's there. It's the law. It's there for a reason. We have enacted it in Parliament. So why on earth we should be puzzled when the European Court of Human Rights tells us when we got it wrong? Genuinely puzzled me. And what we have to bear in mind here is the court wasn't saying that the government couldn't restrict sex offenders being on the sex offenders register for life. The European Court wasn't saying that the government can't restrict prisoners' votes. It was saying that it was unlawful to have a blanket ban. Now, the reason why it's unlawful to have a blanket ban is because you're what's called fettering your discretion. You're not acting as a proper decision maker. You're not weighing up all the options. You're not making a fair, reasonable, and rational decision. And this is James Welch, the legal director of Liberty, saying it how it should have been said. Point being, basically, that if you stopped and looked at it, it was very easy for the government, it's very easy for the media to actually sort of see how this should have worked in terms of it being spun, let alone how it should be interpreted legally. So, human rights. The reason why I dwell upon them is because I make no bones about the fact that I find them hugely useful in terms of the context of the arguments we have, but absolutely essential. They are a safety net in terms of matters of care and support, along with public law principles, and they are there for us to use them, quite rightly, because what is the point of having the Human Rights Act, which enacts the European Convention on Human Rights, if we're not able to say that we think that's inhuman and degrading treatment, and we think that is an irrational or disproportionate infringing upon my family life. Take, for example, community care, healthcare, continuing healthcare, mental capacity, best interest, which are the areas of law which we deal with. And in terms of lessons for children and Charlotte, for example, we're talking about community care, healthcare, continuing healthcare. The mix, the joined-up way in which those packages of care and support and assistance should work. Obviously, add to that, then obviously the issues to do with education, which I'll leave Liz to touch on. The interpretation of legislation of the Human Rights Act was which was compatible with the Convention. It would be unlawful for a public authority to act in a way which is incompatible with the Convention rights. Unlawful in the sense that you're not acting in accordance with what the Human Rights Act says, which in turn says that the European Convention should be part and parcel of your decision making. So we put a genuine foothold in terms of what we're arguing about. There I don't propose to go through this in any great detail. I'm setting out in these notes, and I should say if anybody wants these, you mustn't hesitate to give me your details, and I'll happily send them to you in a soft or a hard copy. By all means, just come over at any time to ask any questions, let alone lend me your details, and I'm quite happy to send them to you. And I've just sort of set out, and again, I don't propose to go through in any great detail, what Article 8 actually says in terms of the Convention. Disability rights. We call it disability rights. That's just an umbrella term for the many different areas of law that we deal with. But from our perspective, it's bringing together the arguments and issues of the law. Obviously, we're lawyers, so something we have to be a little bit dry and boring in terms of how we sort of pitch things, how we talk about things. But that's because we've got to formulate our arguments. So we're all about evidence. We're all about information. We're all about you telling us what it is that is the problem first and foremost. That's not necessarily any easy task for you, let alone ourselves. Gathering together information to find out what's the core issue here. But that's how we work, obviously, because if we get the assessment, if we get a summary of what it is that's been decided, if we get a summary of what your views are, we then know what we're arguing about. That means we can focus on that, because there's going to be strengths and weaknesses and tactical issues we can use. If we're talking about care and support, well, care and support is many things. It's based upon community care support, which is section 2 that we're talking about. It's based upon continuing health care, in Charlotte's case, provided by the Primary Care Trust. We're talking about health care, access to primary health care, GP and such like. And beyond that, we're also talking about provision of education. And obviously, ideally, you want a joined-up way of dealing with all of those things. As you all know, I'm sure, it doesn't work that way in terms of how we work through it. Try and piece together what different arguments we've got, and if we can have one coherent pathway to dealing with it, given that judicial review is mostly the way in which we're looking to tackle it, bearing in mind special education needs tribunal proceedings, then that's what we want to do. We want to bring everybody in to make sure that if we're going to challenge them, we're going to challenge them together. Again, community care is a foundation for independent living. Independent living is the cornerstone of the community care process. Care is what it says. It's care in the community. Again, sometimes misinterpreted, sometimes spun in the wrong way. But community care is hugely important for disabled children, let alone disabled adults, because they're starting out in life. They want the foundation to be able to have an independent life forever and a day. And if you get it right in terms of assessing their care needs at the very beginning, bearing in mind that it's a continual process of review, reassessment, taking on board changes in the way in which their lives change, then you're going to get it right in terms of setting them off in the right direction. And so I suppose what I'm trying to give you a spin about here really is that the work that we do is hugely important in terms of setting children right in the future. This is just the definition of what community care services are. Again, I don't propose to go through this in any great detail. It's important as well to notice that parents are carers, but siblings can very often be carers. Grandparents can often be carers in the loose sense that carers are defined within legislation, quite rightly again. It's all about the provision of care and support. They have their own standalone right to a carer's assessment, which can very often be hugely important in terms of recognition of what it is that the carer is doing and why it is their role is essential to the provision of whatever care and support is in place at present. It mustn't be forgotten in the whole process. Very often, if social services are carrying out what's called a core assessment for children under the Children Act, and part of the core assessment will have a section in relation to carers. Now, I don't have any difficulty with carers being part of the global assessment, provided their particular circumstances, their particular needs are recognised. And I think the easiest example of that is short break provision. Respite as was. Respite services are provided for the child, but obviously have a benefit for the carer, because the carer is then able to recharge the batteries, better provide the high level of care the school they need. Given that the core assessment brings in absolutely everything, every single relevant piece of information about that child's life and circumstances, be it a healthcare issue, be it an education issue, and the core assessment should be the very foundation of the care services provided for that child. Running alongside that should be the carer's assessment, and if the two work together, then the carer will benefit from the provision of the right level of care services for their child, so they can carry on with their full-time role of care. And again, I just noted this because this very often, again, is something which is hugely important in the context of like a sort of robust, rounded package of care services. Housing. If you're living in inappropriate or unsuitable accommodation because it's damp, because it's falling around about you, because you're being harassed by your landlord, or for example because the property needs to be adapted. Well, it's all there. It's all there. Chronically Sick and Disabled Persons Act, Department of Health guidance about joint working between housing providers and social services. Social services have a huge role in terms of assessing absolutely everything which is relevant to the safeguarding of the well-being of that child, whether it's housing, education, whether it's healthcare, etc. And if a local authority ever turns to you and says, well, I'm sorry, housing is not something we can deal with, well, that's not true, because like Department of Health guidance makes plain that yes, they should be working with housing providers to ensure that that child's health and well-being is protected. And where would you argue about that if there was a failure to deal with all and everything, with social services failing in their duties under Section 17? How are we going to resolve that? We're going to judicially review social services because they haven't adopted the comprehensive approach. They haven't brought in all the information that's relevant, including housing issues and adaptations and such. So again, it's all there. Again, just a wee summary about that short break provision, and again, without wanting to sound overly legal, I don't propose to go into any great detail about sort of the idea of the assessment of needs and care planning. We are straying into what is more mainstream community care issues, but it's worth making the point simply this, that the assessment process and the planning process are two very different things. Now, your average social worker tends to confuse those, and so they see it all as one ongoing process. And anybody who's ever been involved with social services in terms of care and support will know that most decisions are made by an internal funding panel within a local authority. Well, from my perspective, I don't really care who makes the decision, so long as they make the right decision. And so if we're dissatisfied with the decision, how do we tackle that? Well, we get our assessments and our planning documents, we find out what it is we're arguing about and why. We put a review submission together, or we just sit around a table and discuss it in the hope that we can twist our arm. We lodge a formal complaint, or ultimately, if we're not getting anywhere and we think we've got a significant legal issue, and I'll perhaps touch upon that in just a second, we threaten judicial review. And so the assessment process is where basically, in simple terms, social services are looking to summarise what a child's circumstances are and what their potential care needs are. So in clumsy terms, you might have 10 care needs, which call for the provision of 20 care services. That's the assessment. The core assessment will set out in some detail, or should, exactly what that child's circumstances are, exactly what that family's circumstances are, and what social services think that child would benefit from in terms of care and support services of whatever kind. The planning process is the point at which social services then take one step on and then decide what they're actually going to provide and or facilitate and or fund. And so that might give rise to this leap over into planning, where you have this concept of what's called unmet need. And that's usually a battleground where you have a decision taken by social services. Well, we're only actually going to provide 20 hours of care and support per week. We think that's sufficient to meet your child's care and support needs. Well, hold on a second, 20 hours is nothing. My child needs at least 30 hours of care and support because I've got these difficulties and I've got this particular dynamic. Well, that's the concept of unmet need, and that's all about getting social services to recognise the true level of your child's needs. No easy task necessarily when you have social workers saying to you, sorry, we don't do that, we have a policy of not doing that. Our policy is that we won't fund out-of-borough placements for, all of which is closing their mind to any number of different things that they can, and in our view, very often should be doing. And again, it comes down to the very simple premise that anything is possible, you're just choosing not to provide it. And we work on the basis that you have to explain yourself. Why are you choosing not to provide it? Now, of course, they can always justify it if they have weighed up all the evidence, all the information that's available, and made a balanced, reasonable, fair, rational decision on the basis of all the relevant evidence before them, which can include, obviously, some of the budgetary restrictions that they have. All local authorities have a duty to manage the limited funds that they have available to best provide services for all those who are in care in need across the city or borough. But they've got to be seen to be doing it fairly and reasonably and rationally, and that's all to do with the public law principles that we were talking about, which are the grounding of judicial review. Put very simply, as a public body, you have a duty to make reasonable, rational, fair, transparent decisions. Common sense. But that, frankly, is very often what the common law is. Fairness. It's all about fairness. Can we look at a decision taken by a public authority and say, okay, I understand why you've taken that decision, I don't agree with it, but but I understand why you've taken that decision, and I'm going to have to take on the chin the fact that you think that particular care need is not critical or substantial. I think it is, and unless I've got evidence to back up what I'm saying, I'm going to have to accept that that's a fair, reasonable, balanced decision. That's all we're looking for. Yep. That's very often the last thing you get, and that's why very often I would be involved, but that's all we're ultimately looking for in terms of any decision taken by government, central or local. In these two cases here, just basically sort of spell that out. They are in community care terms, and I would never recommend anyone read a court judgment. Don't do it, I have to read them, they're incredibly boring. But if ever you want to get a summary of what they actually sort of say, they are quite handy in terms of being able to say to a social worker, well, you haven't gone through your assessment or your planning process. So by all means, if anybody wants any legal material to argue with your social worker, just give me a shout. I've got lots of good stuff. And again, just very briefly, we're touching on continuing healthcare in sort of an adult context, but it's important to recognise that a great deal of the community care legislation, guidance and case law are driven by adult circumstances, but they're equally applicable to children. So that's why we would very often be quoting some of the broad principles of community care, which, as we know, includes social services in terms of providing community care or social care, but also continuing healthcare. And going back to Charlotte's case, Charlotte's health problems were such that she required a high level of primary health care or sort of clinical care in the community. She was out of hospital, but she needed health care on her discharge, and so obviously the health care she was getting in hospital continued into the community. And that's a sort of classic example of continuing health care. And you have a very detailed framework with a process of what we call domains, whereby you go through a process of a sort of slightly clinical tick box exercise of being able to identify in what circumstances a child or adult would need continuing health care. Now, it can very often be of huge importance because continuing health care is provided under the auspices of the NHS as opposed to the local authority, and it is therefore free. Yep. The overlapping community care and healthcare services, the need for joint working. Well, I said at the very beginning in Charlotte's case that we're talking about sort of like some joint discharge planning. And again, that stems from what you might again think of as common sense, that if you have a healthcare and a social care need and an education need, and you need the involvement of the mental health service, etc., that you have like joined up working. That all stems from the pretty extensive Department of Health guidance which is issued to accompany the national frameworks for assessment. And the big chunky framework, which runs to about 100 pages, if ever you're involved in any kind of assessment or planning dispute social services, that really is genuinely well worth a look at. There are sections in there which identify in bullet point form and in narrative form exactly what it is that social services should be looking at in terms of the touchstones for assessment. So, for example, if they were to identify a healthcare or a continuing healthcare need, they would have to bring the primary care trust in to sit around a table in a multidisciplinary way to be able to map out in clear terms what the global care package is for the disabled child. Transition, I touched upon it here simply because, again, this is an area of significant disputes. I don't propose to go through it in any great detail simply for time purposes, but if anybody's got any queries about transition, because it is an important stage in terms of the planning for care services for those from 15 through to 21, and in terms of what can very often be then dropping off a cliff in terms of not getting the care and support post-18 that they should be getting. Whatever your misgivings about complaints, in the context of community care in its broadest sense, not to be sniffed at. Complaints play a huge, huge part in the process of challenging social services and primary care trusts, because complaints don't go away. And the reason for that is that at the end of it, you've got the local government ombudsman and the health service ombudsman, neither of whom will investigate a complaint unless it's gone through the complaints procedure in the first place. So you have to, at the very least, attempt to formally complain about something, even if it's ignored, because if it's ignored, you can write to the ombudsman and say, my complaint is being ignored, I've got no option but to take it before you, and they will then write a letter to the Director of Social Services or the Clinical Director of the PCT, and lo and behold, days later you'll get an immediate response to your complaint, and it will be investigated. It will be investigated within the social services context because you've got the option of going to what we call stage 2, which is an independent, in quote marks, investigation into your complaint. And that's usually an investigation undertaken by a senior social worker outside of the department that you're complaining about. And a report is published, and that will make recommendations in relation to your complaint if they're upheld, and if those are not implemented, then that is immediately triggering the potential for judicial review. because if you've got an independent investigation which is recommending that there be an increase in the care package, and you as a social services authority say, well, no, I'm not going to implement that, well, again, your public law alarm bells are ringing. That doesn't seem fair, that's not rational. There's independent evidence here, together with the wealth of evidence already accumulated and submitted by the parents and the consultant and the GP and the carers who are providing a high level of care, all are saying that this care package is not working. We've tried to deal with it by way of complaint. We're now 8 weeks down the line, we're still no further forward, and now you're telling me you're not going to make any changes. Well, enough is enough. Let's draw a line. Let's genuinely threaten judicial review, which is a remedy of last resort. To say you don't go rushing off to the administrative court. But if we were to then, in those circumstances, take judicial review, we could go before a High Court judge and be pretty sure that we're not going to get a rollicking for wasting the court's time, because we've tried to resolve it by other means. That hasn't produced a remedy for us, and we can show the court basically that we do see judicial review as a remedy of last resort. So again, from my perspective, complaints are important. There's a complaints procedure there. It is something which could offer you a genuine remedy, resolution of the problem you've got in terms of past failings, but also putting right the current problem in terms of future care and support. But if it doesn't offer you a remedy for whatever reason, you're not being listened to, it's not being investigated properly, it's not being implemented at all, then we can genuinely then move forward by way of judicial review, safe in the knowledge that we are able to say to the court that we've tried, we've failed, we know what the remedies are available to us. This case here, Cal, is just an example really of like a situation where a poor solicitor, not a phrase like it's a great deal, but a poor solicitor got absolutely rollicking from the judge because basically they rushed to court too quickly. Availability of public funding, again, I don't propose to sort of touch on that in any great detail, but if anybody has any queries about where public funding legal aid is going in terms of this area of law, then by all means I'll explain that to you. But by and large, with the huge changes in legal aid which are going through, agree with them or not, they are going through. In April of next year, we'll see a massively changed landscape for legal aid, which is going to make it more difficult for a good many people to be able to access legal advice from people who know what they're on about, which is a huge shame. But broadly speaking, legal aid is protected for any number of people that I deal with, including disabled children. There's community care funding, public law funding, disability discrimination funding, and to an extent education funding will all remain in scope. This is another case example, but I'm very conscious of time, so I won't go through that if that's okay. It's just another example of a snapshot of some difficulties that poor Leo had in terms of trying to sort of set him on the right path. A little bit similar to Charlotte's case, but again, it's a very familiar scenario. Sadly, familiar scenario in terms of not being listened to. It's a large part of lots of the cases that we see. Thankfully, again, we're able to resolve them. And again, without needing to issue judicial review proceedings. It's worth bearing in mind that the threat of judicial review very often works. It's only about 4 in every 10 cases that you actually issue court proceedings. That's good. That means in the other 6 basically, by way of pressure, by way of leverage, by way of threat, you manage to sort of turn things around. The way forward, frankly, slightly patronising with the bullet points, but I'm sure you'll forgive me. The key is always to paint a clear picture, and by that I mean, touching on what Catherine was saying, you are the experts as parents. You are the people that I listen to the most, because you know better than me, for sure, but very often better than your social worker or better than your healthcare support worker, exactly what's going on day to day. So as long as you're able to paint that clearly, so long as you're able to make people understand what it is you're dealing with on a day-to-day basis, then it means we've got the grounding for our argument that those who've made decisions which restrict care and support are going wrong. So certainly from my perspective, I want to hear what you have to say. I want you to paint me a clear picture so I know from the off what it is we're likely to be arguing about. Okay? Press the issues and arguments. Again, forgive me if it's patronising, I'm sure you do this all the time. But very often I do see parents who are exhausted. I do see parents who are a bit coy about sort of arguing with social service and primary care trust for lots of different reasons. And yet, those who do press the issues and arguments have raised the arguments significantly at the points at which they come to see me. They've made progress with things, albeit sluggishly, and by pressing the issues and arguments, you've managed to sort of focus upon what it is that we're really arguing about. And again, that's really important because that's important from my perspective because we can't necessarily argue about everything. We're talking about care and support. Well, exactly what care and support are we talking about? Never underestimate your importance, and I think this goes back to the idea that you as the parents are experts. You are hugely, hugely important. Not just to me in terms of getting information to be able to assist you and your children, but you are hugely important anyway. Whether you've got a legal issue or not, you are your children's parents. You are there to provide the very best care and support and love you can. And you must never underestimate the importance of that in the broader context of what it is we might be arguing about in somewhat clinical terms sometimes as lawyers. We're only there to put that argument forward to enable you and your family to have the independent life that you deserve in the future. So if we're focusing on certain issues, it's only because that's going to get you there. The law is there for a reason. The legislation, the guidance, human rights, public law principles, they are there for a reason. They're there to protect vulnerable people. But the way in which you protect vulnerable people is getting social services and primary care trusts to remind themselves as to why they are there. What's their job? It's not about money, it's not about budgets. It comes back to what Joe was saying in terms it's all about making sure people get what they deserve. No easy argument. If you have an argument, put the law there to help us with it. The state is always accountable. By the state we mean local authorities and the central government. They're accountable because we have the Human Rights Act, they're accountable because we have public law principles, and they're accountable because we have an independent judiciary. We're very lucky to have that. Let's use it. Tough times, don't need me to tell you that. Recession or no, it's always been tough times, but I have to say, financial restrictions are biting in terms of the arguments that we're having to have. The arguments are threefold in terms of there being more people who are coming forward with different